Just a quick note before we begin this exploration. The points discussed in this show are our opinion, and it's always crucial to consult with a lawyer to get actual legal advice for your specific situation. This isn't legal counsel, but rather, a journey through information. Hello and welcome to the People Stack. This is an initiative proudly sponsored by Offered, and it's designed to help you navigate the intricate world of workplace dynamics and compliance. Today, we're diving into a really critical, sometimes confusing phase in Indian employment, the probation period,
Yeah.
especially for small and medium enterprises or SMEs. And, what happens when it's time for confirmation? This topic, well, it can feel a bit like walking through a legal maze, right? With all the nuances of Indian labor law.
Absolutely. And our mission today is, well, to try and simplify this whole process for you. We're going to focus squarely on central government provisions, really cut through the noise to get to the core of what both employers and employees need to understand. Things like probation duration, their rights, obligations, and that all-important confirmation process. Think of this as your essential guide, understanding this trial period without getting, bogged down by a ton of legal jargon.
We've really dug deep into the source material for this one. We've pulled insights from some key central laws, like the Industrial Employment Standing Orders Act of 1946, that's the IZOA, and the Industrial Disputes Act of 1947. We're even going to touch upon the upcoming Industrial Relations Code 2020. So this curated information is here to give you a really clear, actionable picture.
Yeah, and it's very important for our listeners to understand that while labor is a concurrent subject in India, meaning both the central union government and individual state governments can make laws on it. For our discussion today, we are focusing exclusively on central provisions. We won't be getting into state-specific laws like the various Shops and Establishments Acts precisely because, well, they vary so widely state to state. Our aim is to give you that foundational countrywide understanding first.
Okay, that makes sense. So if you're an SME owner grappling with HR, or maybe an HR professional making sense of compliance, or even someone who's just about to start a new job in India, this discussion is absolutely tailored for you. Okay, let's unpack this journey into probation, right? Let's kick things off with the absolute basics. So you've hired a promising candidate, or maybe you're that candidate starting a new role. There's this initial phase, often called probation. But what exactly does probation mean in like the official language of Indian labor law? Is it just a casual tryout period?
That's a great way to put it, actually. But think of probation as maybe a bit more than just a tryout. It's more like a structured evaluation phase. At its heart, it's a temporary period right at the start of employment. It's when the employer formally assesses a new hire's performance, their fit with the culture, and, overall suitability for the role before making them permanent. And importantly, it's also a chance for the employee to see if the role and the company are really the right fit for them long term. So it's a two-way street for assessment, if you will, meant to ensure alignment for, hopefully, a lasting relationship.
That makes perfect sense. A two-way street. Okay. Now, this is where often gets, well, interesting for businesses, especially SMEs. India's legal landscape can be quite layered, as you said, labor being a concurrent subject, both central and state governments making laws. So for central laws specifically relevant to probation in the private sector, what are the big players we need to keep in mind?
That's a crucial question, yeah. And it really defines how businesses operate. When we talk about central laws impacting probation, particularly for private sector places, we're looking primarily at two foundational pieces of legislation. First, the Industrial Employment Standing Orders Act of 1946, we'll just call it the IOA, and second, the Industrial Disputes Act of 1947. These acts, along with their rules, basically lay down the groundwork for how employment conditions, probation, confirmation, all that are handled. They provide a framework that prevents arbitrary decisions and promotes clarity.
Okay, so let's talk about the ISOI, the Standing Orders Act. Now, that sounds like something that would apply to maybe specific types of businesses. Who does it typically cover, and how does that affect our SME audience? Many of them might be smaller setups.
Right. So the ISO traditionally applies to establishments employing 100 or more workmen. This means it mandates that these larger places must have certified standing orders, which are essentially formal, legally binding rules outlining conditions of employment probation, termination, working hours, stuff like that. Many large factories, even some industrial SMEs, depending on their size, they fall under this. But here's the key thing for smaller enterprises. If you're below that 100-employee threshold, you aren't mandatorily required to have certified standing orders. However, many of these smaller businesses still look to the central model standing orders. These are government-issued templates or their own carefully drafted HR policies. They often do this just to align with best practices and ensure fairness, even without the legal, compulsion. It's about being proactive, not just reactive.
Ah, okay. That distinction between certified and model standing orders is really helpful. But what about those very small businesses? Maybe a compact tech startup, a small office, or a local workshop. They might only have a handful of employees, clearly not hitting those thresholds. How do they manage probation?
Good question. For these really small setups, where the IASA might not directly apply, the conditions of probation are usually governed directly by the employment contract, or maybe the formal appointment letter given to the employee. This means the clarity and legality of that initial document become, well, paramount. But, and this is a crucial point, even these businesses, regardless of size, must still comply with other overarching central laws, like the Industrial Disputes Act, especially when it comes to issues like termination. So while they have more flexibility in setting their specific probation policies, because no central statute explicitly dictates a universal probation length for them, they can't just operate in a vacuum. They need to make sure their contractual terms are reasonable and fair, to avoid disputes later on.
Right, right. The contract is key there. Now, there's been a lot of talk about new labor codes in India, specifically the Industrial Relations Code 2020. This sounds like a pretty significant shift. How does this new code factor into our understanding of probation? Does it change things for SMEs?
The Industrial Relations Code 2020, or IRC. Yes, it's indeed a very significant development. It's meant to streamline and modernize India's labor laws. It consolidates and amends several existing laws, including the Standing Orders Act we just discussed. Once this code is fully enforced, and it's been in discussion for a while now, it will govern standing orders for larger establishments. Now, what's really fascinating here, and highly relevant for SMEs, is that the IRC raises the threshold for mandatory certified standing orders. Instead of 100, it will now be for establishments employing 300 or more workers.
Oh, wow. 300.
Yeah, exactly. So this means a substantial number of SMEs that previously fell under the 100-worker rule would now be exempt from mandatory certified standing orders. But that said, the code's provisions and its new model standing orders still offer incredibly valuable guidance on best practices for probation. They sort of set a new benchmark for fair and transparent employment across the board.
Okay, interesting. So if I'm an employer or even an employee, the next logical question is, all right, how long is a probation period supposed to be under central law? Is there a standard duration?
You'd think there would be, right? A single, straightforward answer. But it's actually not quite that simple. Central labor law, as it stands today, doesn't prescribe one uniform, fixed duration for probation that applies everywhere to all sectors or all sizes of businesses. However, the existing central model standing orders, those templates we mentioned, they define a probationer as a workman who hasn't completed 3 months service in a permanent post. So that's a common benchmark maybe, but it's not a rigid universal rule for everyone.
But I know from experience, lots of companies, especially SMEs, they often put longer periods in their contracts, don't they? 6 months, maybe even a year sometimes. Is that legally okay if the model says 3?
Absolutely, you're spot on. Many companies do stipulate longer periods, like 6 months or even a year, in their employment contracts or appointment letters. And this is generally not prohibited by central law, particularly for establishments not strictly bound by that 3-month model rule from the existing standing orders. Courts in India have generally accepted reasonable extensions of probation, if these are clearly agreed upon in the contract, or allowed by properly certified standing orders, as long as they aren't, indefinite. The key is reasonableness and clear communication. It can't be used to keep someone hanging on forever.
Right. Reasonableness is key. And how does the new Industrial Relations Code, the IRC 2020, approach this duration question? Does it offer a clearer, maybe longer guideline?
Yes, it does. The IRC 2020 and its new model standing orders, once they're fully enforced, they do bring more clarity here. They will define a probationer as a worker who has not completed 6 months of service in a permanent post.
6 months, okay.
And this is a really important detail. They also explicitly allow for the probation period to be extended by up to 3 months beyond that initial 6.
Oh, okay.
So under this new regime, a probation period could potentially last up to 9 months in total. This gives employers a more defined, maybe longer period to assess suitability, but it also gives employees a clearer time frame for their trial.
Okay, so we've talked about duration. Now, during this trial period, what are the fundamental rights an employer holds? And maybe more importantly, what are their non-negotiable obligations? Seems like there's a balance to strike, right? Between evaluating someone and ensuring fairness.
That's precisely it, yeah. It's a balance. From the employer's side, their primary right during probation is to thoroughly evaluate the probationer's performance and overall suitability. And crucially, they generally can terminate employment with fewer formalities compared to a confirmed permanent employee. The existing central model standing orders are quite clear that for a probationer, no formal notice of termination is strictly required. However, and this is the obligation side, while the procedure might be lighter, employers still have significant duties. Even during probation, they absolutely must adhere to all statutory employment standards, things like minimum wages, PF contributions, ESI where applicable. The terms of probation, including the duration and any extension clauses, must be clearly documented, usually in the appointment letter. And while formalities are fewer, termination should never be arbitrary or discriminatory. It should be based on objective performance or suitability and ideally documented too.
That's a good clarification. So, flipping that coin, what does this mean for the employee? What are their key rights as a probationer? And what responsibilities do they carry during this period? It's a pretty significant time for them, too.
Oh, absolutely. For the employee, it's indeed a crucial phase. As a probationer, you're definitely entitled to your agreed-upon wages. And importantly, all applicable statutory benefits like PF and ESI right from day one, assuming the establishment meets the relevant thresholds. You're also protected under general labor laws against unfair labor practices or discrimination. Now, if a probationer feels they've been unfairly terminated, they can potentially raise a dispute under the Industrial Disputes Act, provided, and this is important, they qualify as a workman under that act.
Ah, the workman definition.
Exactly. It's vital to understand that workman in Indian labor law has a very specific definition. It generally excludes people in managerial, administrative, or higher supervisory roles earning above a certain amount. So not all employees get these specific protections under the IDA. On the flip side, the employee's obligations are clear too. Perform to the expectations set, follow workplace rules, and actively participate in evaluations or training. It's about showing your value.
Okay, wow. Given all these nuances, varying legal thresholds, documentation needs, the workman definition for SMEs, especially those with lean HR teams, managing these probation timelines and ensuring compliance must be a monumental challenge sometimes. I can just picture a small business owner already juggling sales, ops, everything else, suddenly realizing, oh no, probation ends next week, and they haven't thought about the paperwork or the legal side.
You've absolutely hit the nail on the head there. That scenario is incredibly common. Missing probation review, or worse, delaying a confirmation letter, it can lead to significant employee dissatisfaction. It can create legal ambiguities, maybe even lead to claims of deemed confirmation in some situations. It's a classic example where a small oversight, often just because people are busy, can snowball into much bigger, more complex problems down the line. It really highlights why having some kind of system is important, even for small teams.
And this is precisely where modern solutions can really come in and offer a lifeline, isn't it? This is where a platform like Offered, which was mentioned in our source material as a relevant solution, could make a tangible difference.
Precisely. Yeah, platforms like Offered are designed specifically to support SMEs in this exact area. They bridge that gap between, legal compliance and practical day-to-day HR operations. They're tailored for the Indian context. And they automate employee lifecycle milestones, including that critical probation tracking, so they can proactively alert employers about upcoming confirmation deadlines, maybe help generate legally sound letters for confirmation or extension using templates, and essentially ensure that nothing falls through the cracks. By streamlining these processes, digital tools help SMEs stay compliant and consistent. And that builds trust with employees, all without needing huge manual overheads or a dedicated legal team on staff. It's really about making complex compliance manageable, whatever your business size.
Okay, so to quickly try and bring all these threads together for you, our listener, it's clear that probation is a legally recognized trial period under Indian labor law. It's not just some informal thing. It's primarily governed at the central level by the Industrial Employment Standing Orders Act and the Industrial Disputes Act. And looking ahead, the Industrial Relations Code 2020 is set to bring new clarity and revised thresholds for both applicability and duration.
Exactly. And for SMEs, the takeaway is that clearly defining and meticulously tracking probation terms is just absolutely critical. While this period gives you that essential chance for performance evaluation and checking suitability, it must always be handled fairly, transparently, and within clear legal bounds. Timely, well-documented confirmation based on objective assessment. It's not just about ticking a compliance box. It genuinely builds immense trust and clarity with your team right from the start.
So whether you're an employer striving for compliance and looking to foster really good employee relations, or maybe you're an employee navigating your early days in a new role, understanding these central provisions is absolutely key. Key to ensuring a process that's smooth, fair, and hopefully mutually beneficial for everyone involved.
And as we've discussed, with smart, practical tools like Offered becoming available, SMEs have this incredible opportunity now to automate these crucial steps, to proactively avoid compliance gaps, and to truly foster trust and positive relationships with their employees right from day one, all without needing massive HR teams or getting totally bogged down by complex manual processes. It's about using tech to empower your people strategy.
Considering all this, it does raise a powerful question for every business, doesn't it? In an era where keeping good talent is more critical than ever and where your employer brand really matters, how might a transparent, well-managed, and yes, digitally supported probation process not just ensure you're compliant, but actually become a significant competitive advantage for attracting and, crucially, for keeping the very best people for your business? It's thinking beyond just meeting the rules, isn't it? It's about strategic advantage. That's it for this discussion on the people stack. We really hope this exploration has been insightful and practical for you. Until next time, keep learning and keep building truly great, compliant, and thriving teams.